Yeah. I knew you had like some kind of inside knowledge. Yeah, well, I know that like we go to reports and stuff. No. You can go. And you can speak, but you just speak to the citizen. Right. Yeah. Yeah. Right. 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 Yeah. Can't carry it. 6:30. Okay, we'll call meeting to order this evening. Ms. Johnson, if you'd call roll to start.
Matt Seal.
Here.
Steve Donahue.
Here.
Kevin Meadows. Hubert Allen.
Here.
Steve Rosen.
Here.
Harry Donahue.
Here.
William Flippin.
Okay, and we, just for the agenda.
Mr. Chairman, I move that we approve the agenda as presented.
Sorry, Matt Seal.
Yes.
Stephen Donahue.
Yes.
Hubert Allen.
Yes.
Steve Rosen.
Yes.
Harry Donahue.
Yes.
William Flippin.
Yes. All right, approval, we don't have any minutes, we don't have, set any more public hearings, so we'll move right into our public hearing for this evening.
Thank you, Mr. Chairman, members of the commission, Stephanie Johnson, Planning Director. This evening I have for you a public hearing for rezoning request 24-01 Dowdy et al. This application is for a rezoning of 3.249 acres at 5 Old Buckingham Road. Property is currently zoned R2 residential, and the applicant, Mr. George Lee Dowdy III, would like to request that the property be rezoned to B1 business. There is currently an old house on the property and 3 accessory structures. Here we have the vicinity map showing the entire county with the approximate location. This property is at the corner of 13 and Route 60. This map shows the zoning of the parcel and its adjoining properties. As you see, the property northwest is zoned to B1 business. The property southwest is zoned to B1 business. And the property east of it is also zoned B1 business. The property due north is zoned residential, and the property due south is also residential. The property southeast is also residential as well. Here we have the comprehensive plan map that was adopted in December of 2023. The purple areas that you see are what we call the village centers. And this next slide here is the close-up of the Cumberland Courthouse Village Center. The goal of the comprehensive plan is to adopt small village center maps that go into detail specific areas for the village centers. We have not had a chance to do that yet, so this property appears, based on this map, to sit just outside of that village center. Here we have the aerial map that shows the parcel in question. It sits again just at the corner of Route 13 and Route 60 and directly across the street from the intersection of Route 60 and Commerce Road. Here's the current survey of the property, which was done on January 9th of 1970. It does show the house, kind of a circular driveway that shows from the south of Route 13 to the north of Route 60. And it shows 2 of the 3 existing accessory structures on the property. So the owners currently are the heirs of the former occupants, their parents, of the existing residential structure, which they do plan to demolish that old house. However, they are planning to demolish it after the rezoning is approved. Again, the parcels east and west of this parcel in question is zoned B1 business, and the owners are requesting the rezoning of this parcel to business to better align the area for future business development. The owners do plan to sell this lot once it is rezoned. The cumulative planning implications do show that the following goals, objectives, and policies of the 2023 comprehensive plan would be achieved by the rezoning. Goal 8, to create diverse economic development opportunities. Objective 8.1, the county will encourage economic development in well-connected village centers such as Randolph Village Center, Cumberland Courthouse Village Center, and the Cartersville Village Center. Objective 8.2, the county will encourage the development of service and retail businesses to meet the needs of the current and future populations of the community. And objective 8.4, to facilitate the conditions needed for new and small, not slam, I apologize for that, new and small businesses, particularly in the village centers. The following 2 slides are the existing business uses that are proposed in the B1 zoning districts. A few of these that are listed are child care centers, bakeries, banks, barber shops, dry cleaners, laundry services, financial services, general stores, health clinics, lumber and building supplies, medical facilities, office buildings, professional offices, restaurants and drive-ins, retail food stores, service stations, vehicle painting and upholstery repairing and rebuilding stores, wear and apparel stores, and veterinary hospitals with no outdoor confinement. For public engagement, the notice of this public hearing was published in the Farmville Herald on November 6th and November 13th. The adjoining property owners were sent notice of this hearing via first-class mail on October 28th. The Department of Public Works has confirmed that this parcel is within the mandatory connection area for both public water and sewer. However, the house that is on the property is currently using an existing private well and septic system. The application was submitted to VDOT for comment. Since there is no specific plan for the type of development or use of the property, they were unable to share the extent of any potential traffic impacts to this corridor at the time as they are unknown. VDOT did provide that the existing entrance on Route 60 does not meet the commercial entrance requirements. The extent of improvements to the entrance and any turn lanes needed will be addressed by VDOT at the submission of a site plan for development. Other than those already mentioned, staff has received no other comments for or against this rezoning request. And with that, I'll take any questions that you have. Yes, sir.
The, Marshall, 5783, is anybody living there now?
That is a church,
That is, okay.
yes. Any other questions from the commission?
Anybody have any other questions about anything?
Mr. Chairman, because this request needs to,
I'm sorry, this is a public hearing, so we do
I'm
need to
sorry.
open and close the public hearing.
So we'll open the hearing now to the public. I don't believe there's anybody signed up to speak. The applicant is here, but has nothing further to add. Application is pretty clear.
It is
We'll
not
close the
present.
public hearing. What's that?
I'm sorry, the applicant is not present.
Oh, I'm sorry, I misunderstood.
That's okay.
We'll close the public hearing.
Mr. Chairman, because this request meets the intent and spirit of the zoning ordinance and comprehensive plan, I move that the planning commission recommend to the board of supervisors approval of REC 24-01, and zoning to B1 business.
Before we ask for a second, I'd like to add something. I'm in favor of approving the application with the stipulation that goes along with the approval, that once the applicant or new purchaser decides what they're going to build there, that they make sure that the entrance to the property goes along with VDOT requirements.
That's a given capacity. I mean, that's not something we need to incorporate into this request because VDOT has control of both roads adjoining the property and they're going to have the final say so as far as the entrance and exit. I don't see where that's necessary for us to signify it in our ordinance to the board of supervisors, because ultimately, what we want is controlled by VDOT.
Okay, that's fine. Then we'll ask for a second.
Second.
I'm sorry, who made this?
Steve.
Mr. Donahue, thank you. Matt Seal,
Yes.
Steve Donahue,
Yes.
Hubert Allen,
Yes.
Steve Rosen,
Yes.
Harry Donahue,
Yes.
William Flippin.
Yes.
Okay. We'll move on to general citizen comment tonight. Daniel Lance. Good evening, Mr. Lance. Thank you very much for coming. You have approximately 3 minutes.
Sure.
And please speak up.
Sure. Yes, will do. My name is Daniel Lance. I live on Cumberland Road. The reason I wanted to speak tonight is I have mentioned once or twice before in some hearings here for planning and zoning, as well as several times recently to the Board of Supervisors, just how important the job that goes on here in this section as well as the section of the Board of Supervisors is. And I would hope, and I'm not accusing that I feel like everyone here does, take the job extremely serious. The things that are approved inside these meetings carry weight years down the road. The reason I'm speaking tonight, the biggest reason is due to an issue with noise. There was a building that was asked to be built and rezoned from A2 to B1 back in probably 2013, 2012 maybe. And it was done, it was approved by the planning commission, sent up to the board of supervisors. They approved it. Even though 6 people came to speak, 5 spoke against it, 1 spoke for it, and 1 outweighed the 5. And the structure was built, the property was rezoned, and 3 years I've lived here, going on 3 years I've lived here, I have not had a moment's peace, which is advertised on the county's website, due to the consequences of that structure being built, the rezoning process. So I wish to remind everybody just how important it is, the work that you guys do. Take into account whether or not it's going to be something that's useful, whether or not it's going to be something that's good, whether or not it's going to bring value. Those are the most important things. And a building that nobody wanted around it showed up. Every resident, which I just spoke to 2 of them today again and got some signatures. One of which has had her fencing destroyed on the property because people from that building have run into it. Another one has put rebar around their mailbox because it kept getting knocked down. Just another one across the street has had their mailbox knocked down several times from people leaving this building. One lady is actually moving. She closes on the house December 31st. And she is leaving her husband here in this county. And she is moving to another state because of that building. So I will bring all of this up in future meetings, trust me. But right now, I just want to be very cordial and very kind and just say, please remember, it is important what you guys do here. Everything you decide carries weight years down the road. So we could just remember that. I appreciate it. Thank you for your time.
Thank you for coming in. Old business?
All right, thank you, Mr. Chairman. Under old business, the first item I have for you is potential code amendments, specifically Code Amendment 2404, Board of Zoning Appeals. We had a workshop scheduled for earlier this month, which was unfortunately canceled. So I figured what I would do this evening is put that code amendment in our packet for this evening. You'll find that on pages 18 through 23 of your board packet. And I've also included that in the PowerPoint this evening. So the Board of Zoning Appeals section of our code is required to be updated due to the state code, which our ordinance is derived from, being updated in 2020. I can only assume that with the turnover in staff in this department prior to my arrival, this was missed. So our ordinance now needs to be updated in order to reflect the changes that were made in the state code. So the ordinance, the code amendment that you have before you this evening is just that. It is the updates that are required based on the code change from the state code. So in your planning commission packet, you'll find a complete section from, let's see, Chapter 74, Article 1. Let's see, so 74-2, and then Chapter 74, Article XIX, Board of Zoning Appeals. So it starts at Section 74-821, and then it goes through. So you have the entire article in your packet. However, on the PowerPoint, I only added in the items that showed the revisions. So in the PowerPoint, the first section is Chapter 74-2, and this shows anything that is being either added or deleted. So the definition for variance is being revised to include that variance means, in the application of this chapter, a reasonable deviation from those provisions regulating the size or area of a lot or parcel of land, or the size, and we're including height, area, bulk, or location of a building or structure, when the strict application of the chapter would, and we're adding in, unreasonably restrict the utilization of the property, and then we're removing the result in unnecessary or unreasonable hardship to the property owner. You'll see a few sentences down, we are removing the intended spirit and purpose of this chapter. We're removing and would result in substantial justice being done. The next page is section 74-821. It discusses the appointment of Board of Zoning Appeals members. This was just being restated. So it was the same sentence that was found in two different sections of the same paragraph. So this was just kind of reworded here. That was more of just an administrative change. The board shall choose annually its own chairman and vice chairman who shall act in the absence of the chairman. And then it was the very next sentence, it just said the same thing. So I took out that very first sentence. Section 74-822, powers and duties. Here you'll see the insertion of a few new sentences here. And again, this comes from the state code. And that is 15.2.2201 for the definitions. And I did include the entire chapter from the state code in on your locations this evening. (74-822A2). We were removing that entire chapter from the previous page. Here we go. This is additional language that was being removed from that same section. And then here's the new 74-822A2 that is being added based on the new code section from the state code. Here's 74-822B, C, and D. You'll see there's just a few changes here. No variance shall be considered instead of authorized. And then section D, instead of in authorizing a variance, the wording was changed to in granting a variance. Section E, the property upon which a variance has been granted shall be treated as conforming within the regulations of the chapter. However, the structure permitted by the variance may not be expanded unless the expansion meets the general requirements of the chapter. Where expansion is proposed within the area of the site or part of the structure for which the variance would be required, the approval of an additional variance shall be required. And again, that section comes from the state code. Section 74-824, appeals to the board. There's a very bottom sentence here. The zoning violation or written order shall include the applicable federal appeal fee and a reference to where additional information may be obtained regarding the filing of an appeal. This next section here is, of course, an addition. The appeal period shall not commence until a statement is given and the zoning administrator's written order is sent by registered or certified mail to or posted at the last known address or usual place of abode of the property owner or its registered agent, if any. The owner's actual notice of such notice of zoning violation or written order or active participation in the appeal hearing shall waive the owner's right to challenge the validity of the board's decision due to failure of the owner to receive the notice of the zoning violation or written order. 74-825, the appeal procedure. Appeals shall be submitted to the Board of Zoning Appeals in the care of the zoning administrator. A second copy shall be mailed to the individual official, department, or agency concerned, if any. In our instance, it's the same person, so it would be me, but of course this is coming from state code, so we had to make that revision. 74-825B, completed appeal application packets shall include a fee assessed by the Board of Zoning Appeals in section 2.3 of the county ordinance. The previous ordinance that we had assessed a fee of $20 made payable to the treasurer, but that did not, that was in, that did not match what we already had fee-wise in section 2.3 of our ordinance. So I had to take that out and then just reference that section where all of our fees are assessed, just to make sure that it was all in compliance. 74-827, certiorari to review the decisions of the board. Any person or persons jointly or severally aggrieved by a decision of the Board of Zoning Appeals may file with the clerk of circuit court for the county a petition that shall be styled in R.D. date, decision of the Board of Zoning Appeals of Cumberland County, specifying the grounds on which the agreement within 30 days after the filing of the decision in the office of the board. And again, that's section, the third to the last sentence in 74-827A. That styling did come from the state code. Section B, upon the presentation of such petition, the court shall allow a writ of certiorari to review the decision of the Board of Zoning Appeals and shall prescribe the time within which a return must be made and served upon the Secretary of the Board of Zoning Appeals, which shall not be less than 10 days and may be extended by the court. That next sentence is being added. Once the writ of certiorari is served, the Board of Zoning Appeals shall have 21 days or as ordered by the court to respond. In keeping with that same section, any review of a decision of the board shall not be considered an action against the board, and the board shall not be a party to the proceedings. However, the board shall participate in the proceedings to the extent required by the Code of Virginia. The county, the landowner, and the applicant before the Board of Zoning Appeals shall be necessary parties to the proceedings in the circuit court. Section D, the Board of Zoning Appeals shall not be required to return the original papers acted upon by it, but shall be sufficient to return certified sworn copies or portions thereof as may be called for by the writ. Section E, the circuit court may reverse or affirm, wholly or partly, or may modify the decisions brought up for review. Section F is completely new as required by the code, and I believe that is in place of section D, which is just below it. Section G, costs shall not be allowed against the Board of Zoning Appeals unless it shall appear to the court that it acted in bad faith or with malice. In the event the decision of the board is affirmed and the court finds that the appeal was frivolous, the court may order the person or persons who requested the issuance of the writ of certiorari to pay the costs incurred in making the return of the records pursuant to the writ of certiorari. If the petition is withdrawn subsequent to the filing of the return, the Board of Zoning Appeals may request that the court hear the matter on the question of whether the appeal was frivolous. And that was a lot, but that is what I have so far. And that has been sent to the county attorney. That is our second draft, and he has approved that draft. We have both looked at the state code and confirmed that does satisfy the requirements of the state code. Does anybody have any questions? And do we want to have another workshop to go over this more in detail before we request to set a public hearing?
That was several questions.
Yes, please, ask them.
A couple of questions. First of all, I apologize, I have not gone through this with fine tooth comb, so
It's okay.
I may sound incoherent in my questions. Can you articulate what is directly from the Virginia Code and what is particular to ours?
So the majority of this comes, majority of the changes come directly from state code. The one thing that I know is not from state code is regarding the fee. That one section regarding the fee, because that I had to change, so that is on page 22 of your packet, 74-825, item B is in bold.
Right. Yeah, obviously that can be from the Virginia code.
Correct.
Addresses our code.
Correct. Yes, sir.
So, for example, the language on 74-82281, that is directly from Virginia code.
Yes.
So the question I have there, as well as over on 74-827E. If I'm understanding this correctly, this is just maybe a procedural thing, right? Where it's assumed the county's correct, and they have to be proven incorrect.
Correct.
Is that basically what it's saying? So it's kind of the opposite of innocent until proven guilty. It's the county's innocent until proven guilty. Is that right?
So this is, let's see. The court shall allow a writ of certiorari to review the decision of the Board of Zoning Appeals.
Where is that?
That is on page 22, 74-827.
Yeah, that's not what I'm talking, letter F.
That's correct. So that is, all right, let me go back to your first question.
Yeah, and that was, so I'm on page 19, 74-822A1.
All right, so that's under powers and duties. So in this packet of the state code
Right?
that I've provided you, that is on page 5, powers and duties, 15.2-2309. To hear and decide appeal from any order, requirement, decision, or determination made by an administrative officer that is directly from the code. The decision on such appeal to be based on the judgment of whether the administrative officer is correct. Determination of the administrative, that is exactly from state code, section 15.22309.
Okay.
So that answers your first question.
Yeah, and just so that I'm clear on
Yes,
what is meant by the state code on there, is that the assumption is the county did everything right, and those who are appealing have to prove that it's not correct. Is that what it's saying?
yes, so that is correct. The Board of Zoning Appeals, the decision of the appeals, yes, is that the judgment of whether the administrative officer was correct. The determination of the administrative officer shall be presumed to be correct. At a hearing on the appeal, the administrative officer shall explain the basis for the determination, after which the appellant has the burden of proof to rebut such presumptions of correctness by a preponderance of the evidence. Yes. And then yes, that also comes from the state code.
Right, and then, my other question is on, section 74-824, last sentence of paragraph, or last sentence of section A. I've asked this question before, and I don't remember what I got as a response, so I'm sorry if I'm asking it again. I know I'm asking it again, but I'm not satisfied that I know the answer to it. So, the owner's actual notice of such notice of zoning violation or written order or active participation in the appeal hearing shall waive the owner's right to challenge the validity of the board's decision due to a failure of the owner to receive the notice of zoning violation or written order. Remember, I asked about this before, and I wanted to get some clarification on what that meant. Does that mean that?
So,
yeah.
Their participation in the hearing waives their right to appeal based on them not receiving the notice of violation. So them knowing about the hearing and participating in the hearing waives their right to appeal it based on them saying they didn't receive the notice because they're participating.
Okay, so could they not have heard it from a neighbor and gotten incorrect information?
Yes, but they're still participating in the hearing, so they heard about, they knew about.
Basically, it's just striking one of the criteria that they have to appeal. If they do not receive a notice and do not participate in the hearing, they can appeal to the BCA. But if they participate in a hearing and all, it's assumed that they knew of it since they were there, and they could not use that as a
I didn't know.
mode to appeal.
Right, I understand, but what I'm trying to prevent is trusting in the mail system.
Correct.
So I do not want somebody to be penalized because the mail didn't get to their house.
Right.
So is that what that's saying?
So that's saying that, yes, if they didn't receive it by mail and the hearing, if we're to go to hearing, and they, as long as they participated in the hearing, they can't
They're acknowledging that they knew about the,
right, by participating in it, they acknowledge that they knew about the hearing. They acknowledge that they knew about the
received it
notice
by
violation.
mail.
But if they did not participate in the hearing, or did not, and used the argument that they did not receive or know of the hearing, and they were not there, they can proceed with
Yes.
their appeal.
Yes. And that is, on page 9 of this section, this here, it's on page 9.
Yeah, I remember you showing me where it was, and
Yeah.
but I still was not clear on what it meant. So, I mean, just because Virginia code has it in there, doesn't necessarily make it comprehensible, if you know what I mean. So, all right, did you have a question about the time period on there?
I think it was just a type draft where, section 74-827. Sign, code seems to read in the document is,
74827,
section A.
any person or persons jointly or severally aggrieved by any decision or any aggrieved taxpayer.
Just the quoted part about the sign
In
in
RD.
the decision board.
All in date decision.
I think that's,
But I mean, in regards or something, because in
it's probably RE, not
Yeah.
RD.
right next to each other.
Thank you.
does anybody else have any other questions regarding this? So, Mr. Johnson, I guess the question here now is, do we want to move forward with having another workshop with this item? Or if not, do we want to approve it as it is?
So I guess, yeah, my question is, do we want to schedule a workshop to look further into this, or do you want to go ahead and do a request to set up a
I would personally prefer a workshop. I know we had one scheduled, and due to illness and work issues and all, we couldn't develop a quorum for it. I personally feel a workshop, where we could sit down and devote the evening to just this one item would be beneficial. And if it was possible, I'd like to have our county attorney in attendance for any legal questions that could arise, or legal experts although Ms. Johnson does a great job,
I'm gonna
he would
return.
be a little more
Yeah.
familiar with the legalities. But that's just my thoughts.
I'm not necessarily opposed to having a workshop, I'm just not sure what more we could learn at a workshop. I mean, the language is right from the Virginia code, so it's not like we can argue with that. I mean, we're basically just saying, we're bringing it up to what it says in the Virginia code. So I'm not sure what we would benefit by having a workshop. I mean, you know, if everybody wants to have a workshop, I'll show up, but, you know, I'm not sure what would be gained by it. I mean, do you have questions? Do you need an answer?
I don't know if I have questions or not at the moment. I've gone over it once. I'd like to read it the second time, in a little more detail. My biggest thing is that something that where we have the state code verbatim basically included in this ordinance, is that some way legally we can tweak it and add something that would be more beneficial to the county, the citizens, the members of the PTA or whatever.
Well, if I'm not mistaken, Virginia code trumps county code anyway, right?
Yes, that is
So,
correct.
I mean, even if we were to tweak it, in the appeal, they would say, you know, county had it wrong. So,
If I can, Mr. Chairman, we don't have to take action tonight. So this was just brought up for information this evening. We don't have to take action tonight. We can sit on it, we can digest it this evening.
If that's the case, why don't we do this? Why don't we add it to the next agenda? That gives Mr. Allen a chance, if you'd like to read it in depth. We don't set it up as a workshop item yet. If we decide after the next meeting that we need a workshop, we can do that. But that way it gives Mr. Allen and anybody else who feels they want to dig into it a little deeper time to do that.
In the meantime, I'm here. If you have questions, you can email me. The county, I can email the county attorney with any specific legal questions, if you guys have. So that's fine with me. No action is required or needed at this time.
Okay, let's go ahead and do that. Everybody agreement on that?
All right. Moving on, the next item on the agenda tonight is just a brief Cobb's Creek Reservoir update. Things are moving along. It is very green out there. Last time I was out there was actually on Halloween. I did not wear my Halloween costume out there, thankfully, but I wasn't the only one. There was only one person dressed up, so I didn't feel too bad. I did get some new photos. I'm hoping next month I can kind of do a side-by-side. When I did pull up the photos I shared last month and compared those to the photos I took today, you can see a little difference in where the trees are, the water levels are. The water levels are rising slightly, but with us not having much rain last month, you know, they weren't able to impound water as much as they would have liked. So they're moving slowly but surely out there. So this is from the eastern side of the dam. Here is another picture from the western side of the dam, looking back towards the Faro area, looking south.
And eventually that's all going to be underwater.
Absolutely. So this picture here, you can see this building. This building here, my pictures are not great, but the water level will be up to the very bottom of this structure here. You can see water level will be up to the bottom of this structure here, actually. That's when it'll be at full depth.
You can see water from 690 now.
You can, good. good. So they're getting there.
Is any of it open to the public yet?
No, not yet. The contractor is still there, they're still working, so it's still considered a big construction site. And here's the last picture looking at the very western portion of the main dam. So I did reach out to Henrico County, and we are looking at potentially March for a next site visit for the planning commission. So fingers crossed, we'll get there and water levels, maybe won't even be able to see grass by the time March comes up here. We don't know yet. Fingers crossed. So, Mr. Chairman, the next item on the agenda that I have for you is new business.
Solar update, we have a solar update?
Oh.
I was on the whole business.
It sure was. I apologize. So, solar update, the Dunn and Rowlett projects in the southern end of the county, they have started clearing land. They're starting to put their initial perimeter installation up. So they're putting up their silt fence. They're just starting to clear land. This week will be my first time going out to each of the sites. So I'm excited to see kind of what they're doing. They are going to be doing a new topo survey via, I don't know if they're going to be doing drones, but once they're going to go ahead and clear, let me rephrase that, they're going to go ahead and clear cutting the trees on the entire site. So they're not grubbing stumps on the entire site. They're going to go ahead and clear cut the trees, so they're going to leave the stumps.
Except for the buffers, right?
Of course, except for the buffers,
Okay,
but
just making sure.
the construction area that they have permitted to clear, they're going to clear cut the trees, leave the stumps, and then redo the topo to make sure that the ENS measures, the sediment basins, the traps that they have planned for based on the original topo maps are still adequate. Sometimes when they have these large trees and they do the aerial topos, they can be deceiving with the trees. So to ensure before they really dig up the dirt and then try to install these set basins and these ENS measures, and then they move on to like the second phase, and then they realize that the ENS measure, the set basin they installed isn't adequate because the topo was off. They want to ensure that it's being designed and installed properly, and it's going to be suitable for the amount of dirt that they are going to actually be disturbing in the amount of land. So I gave them the approval to go ahead and clear cut, leaving the stumps, not disturbing any actual soil, but clear cut the entire approved acreage for the disturbance for the project. That way they can get a more accurate topo to ensure that the set basins, ENS measures, and stormwater management measures that are going to be installed are designed and approved based on the accurate numbers. So they're getting ready, they've started the silt fence, they're actually putting up super silt fence. They're also going to be installing an earthen berm for an earthen dam. In addition to the super silt fence, which was not required originally, but because I gave them the go-ahead to clear cut just to be on the safe side, because we don't want any environmental issues, they are going to go ahead and install an additional perimeter measure, that earthen berm, to ensure that no soil leaves the site, and that goes for both projects. So this developer understands that they are the guinea pig in Cumberland County when it comes to solar development. And I've made it very clear that we are watching them, the county is watching them, the citizens are watching them, and that we expect nothing but the best, not just minimum, but we're going to be watching them very closely. So they know that they got to do things the right way. So, and they've been very good to work with. They've been, offering more than just what is required. They've been very transparent and forthcoming with information, so so far so good on those two projects.
What organization is monitoring the quality and level of the water there?
Level of the water for the solar projects there.
You want to take, yeah, the water treatment.
So that would be stormwater, and that would be DEQ.
Have they been there yet?
They don't normally tell me, there's two separate permits. We've handled the E&S, the erosion and sediment control, and then DEQ handles the stormwater. So they don't tell me when they come out. So that I don't know.
New business.
Mr. Stinson?
Only two things I had, one she just answered was clarification about the visit that y'all requested out to Cobb's Creek, and I guess she's got a date, I was confused. The way the initial
Yeah.
was written, so that answered my question, so at least we have an idea of when y'all want to go, or they have an idea of when they can, for those who want to go. The other thing is, I just want to make sure everybody's, understanding of the joint workshop we had with the planning commission, has that been explained?
From what I understand from the last meeting, the last,
Workshop that we had?
gathering, right, was, the planning commission has regular workshops scheduled, and I'm assuming
So
that
we're
was.
gonna try to get them together. That was a big thing is, for me, and I know the other members, we wanna make sure that we're following through with you guys in the most proactive way we can be. If you request a visit to Cox Creek, that we understand that, and if it doesn't come to fruition, that we can try to make it move along a little bit better. Same thing with workshops, because Kevin Meadows, I'm not sure if you were here, but we were talking about having workshops last meeting, last planning commission, and we had a board workshop, and that was one of the things we were trying to iron out, make sure that whatever we decide to do, that we do it, benefit us, you guys, us together, and just making sure the information that we need to share is actually shared. Okay? And whatever we need to do, I would personally like to make sure that everybody here knows that we all came up with, especially once Eric was speaking a few things. I know you were at the meeting for a while, so.
Yeah, to my knowledge, it was, we had discussed the board coming in on the
Exactly.
joint.
And I just want to make sure
existing
we're getting
planning
dates and everything to make sure they know that that's not a drop on or anything like that. I want to make sure that you know that's whatever y'all are happy with, we agreed to make sure everybody's included. Okay? Nobody feels singled out. Sometimes meetings can be scaled down, pass on information because not saying it doesn't pertain to everybody. We just want to make sure that as members of the planning commission, that we're listening. And anytime you have something to kick out to us, please just let us know. Because again, some of the things that have been brought up, I do go and talk to them about, making sure, I mean, pretty much everything. Make sure everybody's aware of any concerns you may have. And I try to make notes throughout this. I mean, like when you were asking about clarification on codes, yes, there's things that we need to know that are concerning. That's all I have.
Next item I have for you is the planning department monthly report, and that can be found on pages 24 through 28 of your board packet. For the month of October, of course, we do have the two pending applications. The first is the CUP 2401 for Green Ridge Recycling and Disposal Facility. That application is still pending. I have received revisions to the application statement and the proposed site plan. The last piece of information did come in Friday while I was at the office, so I have not had a chance yet to review that and verify that it does meet the requirements and that the application would be deemed complete. The next is, of course, the rezoning 2401 for Dowdy et al., which we did have the public hearing tonight for. There was one commercial accessory zoning permit issued, 9 residential primary zoning permits, 5 residential accessory zoning permits, and 1 farm structure zoning permit. There was only 1 subdivision approved on Brown Road, and we have 36 pending. There were 6 surveyed existing lots approved and 29 pending. For the commercial erosion and sediment control permits open, we do have the 3 current, 1 Cobb's Creek, and then the 2 solar facilities on Route 45, the Dunn and Rowlett projects. There was 9 residential erosion and sediment control permits issued in October. And then at the bottom of 26 and on top of page 27, you'll see the potential code amendments, one of which is that Board of Zoning Appeals code amendment that we just reviewed as well. Next, you'll have the building inspections monthly report, which is on pages 29 and 30 of your board packet. Last month, I do believe, it was discussed to include the year-to-date numbers on this, monthly report, and I did get with the building official, he has added that information as well. So for the month of October, there was, 3 single wides, 3 double wides, 8 new homes, 3 garages and carports, 73 miscellaneous permits, so that could be electrical, plumbing, mechanical, change of use permits, ones where a mechanic lien agent was added, things like that. So the total permits for the month of October were 92. Total fees collected for the month was $13,680.33 for a total estimated value of $2,254,315 and a total of 7 certificate of occupancies issued for a year-to-date total fees collected of $108,877.44 and a total estimated value of construction of $21,267,783.42 and a total COs issued of 66. The next item under new business was the draft community development agritourism. Yes, sir, I'm sorry.
Sorry, I need to stop your train there.
No, that's okay.
On the potential code amendments,
Yes, sir.
we back up to that page 26.
Yep.
So the Board of Zoning Appeals and the noise ordinance are the only 2 that really have been kind of in the process. I mean, I know we've talked about some of these other ones, but can you clarify where they are in the process of some of these?
Sure. So the noise ordinance I was bringing up, and then the county administrator said that they were going to be looking further into that. So they asked me to kind of let that one go for a little while. That was just going to be a textual change, but they are going to be looking more into some different changes in that. So they just asked me to kind of set that one aside. I've not heard any more regarding that ordinance, so I don't know where that one is in the queue. The erosion and sediment control ordinance, I am about halfway done with that ordinance amendment. That is based on the state code change as well as the combination of the erosion and sediment control and stormwater ordinances and the regulations. And that was effective July 1 of this year, and it will go into effect June 30th of next year. So that one is about halfway done.
We should probably see that one in the spring, maybe.
Hopefully sooner than that. Fingers crossed, but yes, no later than spring. Going back up to the top, second from the top, the zoning ordinance multifamily housing. That is something that I wanted to do by the end of last calendar year. And just with being one person or, just understaffed, that's honestly where a lot of these have kind of just stalled, is just being understaffed. There's just not enough hours in the day, honestly. Zoning ordinance regarding meat processing, that's pretty much where that came from, or where that stands as well. The business uses, the commercial kitchen, the overlay district, and.
Are there people waiting on those? I remember we had somebody come requesting both those last 2, the processing of agricultural products and the commercial kitchen, I think about a year ago, wasn't it?
So I did have.
One of those things?
I did have one gentleman ask about the processing of, the meat processing. But he hasn't been, it wasn't a serious request to my knowledge. He was like, yeah, I want to do this. But he has an existing business in another locality. So he's looking, yes, to, I think, eventually move his business here, but it's not a rush. He doesn't have an application. He's just asking questions at this point. So there's no application pending. for any of these.
But if we were to have an ordinance that was very,
Up to date?
well, I was thinking more in terms of open to business
Uh-huh.
regarding that. You think that would incentivize that or no?
Probably, yes, sir.
Or maybe wait on that for us?
I haven't seen him in about 6 months. He has not called. So, yes, sir. The zoning ordinance for the multifamily housing and the mixed-use zoning district are the two things that I really wanted to get done. That was my goal. But again, with the lack of staff, that's really where a lot of things are just not being able to get done. So that's
Okay.
kind of the bottom line.
And then on the business uses countywide one you have there at the very bottom, carries over to the next page.
Mhm.
If I'm understanding that correct, basically what you're trying to say with that is that it's going to, all of subset is gonna be included in the broader.
Correct.
Yeah.
Yeah, so in the, I believe it's in the industrial zone, you only have M1 and M2. So in the M1 zone, you have light industrial
Right.
uses. And then you have what's approved with the conditional use permit. And then in M2, everything that's approved in M1 by right is also approved in M2.
Right, yes.
And that was the intent with the business district as well. What's permitted by right in B1 should also be permitted by right in B2. And as well in B3, but that's not quite how it's listed.
Okay,
That's how it should be listed, but that's not quite how it is.
right, okay.
So that was the intent of that one.
Yeah, that's what I thought. Okay. And what is meant by improved appearance on that next one?
So the overlay district standards, standards that require improved appearance in the mixed-use district around the courthouse. So we had at one point a historic district overlay that was designed and approved as part of the historic courthouse district, but it was never enacted, I guess. There was an engineering company that came in, and I'm sure there was plenty of funds that were spent on this engineering service that was done probably 15-ish years ago now, in order to create this beautification of the courthouse district. There were design standards that were set. There were decreased setbacks that were set for this courthouse area in order to better utilize this area. It was all approved. I say approved loosely, but it was never enacted. So that was kind of where I was going with that area, with that zoning district or overlay district, to kind of have a more cohesive look. Because through here, you've got a bunch of different standards, I'll say, when it comes to
So you want
the
to
types of
basically,
signs.
you want to basically have a homeowners association for the courthouse.
No, but I feel like if we have a set standard for like the types of signs that you can use, or the size of signs that you can use.
Yeah, so I mean, basically what I'm saying though is with that is that you want to get more regulation on the courthouse than the broader regulations in the county clerk, is that correct?
I would like village centers to have a set range of designs that they can choose from, yes.
This is like on Dollar General or all these dollar stores, that was still here, they wanted the building, like courthouse.
Right.
Instead of just start them up and do inside,
Right.
that was the price that was never panned out. It's a shame.
Right.
Okay, that's all the questions I got on that section. Thank you for indulging me.
No problem, anytime. draft community development agritourism policy. I'm keeping that item on the agenda, so that way, when it does come up and I do have an update, it's already there. But I do not have an update for you currently. The county attorney has been very busy with many different things. So I do not have an update for you on that at this time.
Okay. General comments from anybody? Has there been any status change where we are getting you some help?
No status change.
That's bad news.
That is not good news, no sir. I will say the advertisement is out there. They're advertising for a part-time position. But I'm advocating for a full-time position.
Any other comments? Can we get a motion for
I
this?
believe that we adjourn to 16 December 2024 or sooner than we need.
Second?
Second.
Matt Seal, Steve Donahue,
Yes.
Hubert Allen,
Yes.
Steve Rosen,
Yes.
Harry Donahue,
Yes.
William Flippin.
Thank you.